Good evening. Hello, and welcome to tonight's program on development at work. I'm starting a little late because I had some technical difficulties, but we've managed to sort those technical difficulties out, and we can now start the program. So, on this program, I'll be focusing on and I'll be focusing on land matters, land law, and legal matters. And I'll also be focusing on family and family and financial matters. I'm going to share my number in the chat. So share the live 592 694 5585, and my email HOMOGY at yahoo.com. So you can feel free to contact me, and we can have discussions on any of the matters that I'm discussing tonight on the program. So this program is Development at Work, and we'll be focusing on a number of areas, like I said in the program on Tuesday. This program is going to focus on building our dream communities, building our dream families, building our dream lives, building our dream. It's a part of the Building Our Dream Guyana movement. And like I said on Tuesday, some of the aspects of this program, you can use it for building your dream Trinidad, building your dream Barbados, building your dream Jamaica. So you can use some of the programs that we'll be using within this or doing within this program. So this program really focuses on how we can help you. I see myself as a technical specialist, technical expert, providing technical expertise. I'm a sustainable development practitioner and a rule of law advisor. And so I'm going to be using my skills and my expertise to help you, to help families, to help communities, to help individuals in various areas as it relates to development and rule of law. So we will be developing not only rule of law as it relates to development, and we'll be focusing on environment, developing an environmental industry in Guyana. We'll be focusing on developing a service industry in Guyana at the community level, and we'll be focusing also on how can we transform your communities or help you to transform your communities into your dream community. How can we help you to transform your families into your dream family and to transform your life into your dream life? Those things. And what we'll be looking at in terms of how we will help you, we'll be looking at structure and building structure, more structure into your lives, into your families, into your communities. And, just today I was talking with a colleague of mine. I saw a letter that he wrote in, or a letter that he wrote in, not a colleague really, but someone who I know, who wrote a letter in in the Village Voice newspapers. And I thought that the letter was very important and it was relevant to what we're discussing on this program. This is Randy Critchlow. And Randy wrote, the title of his letter in the Village Voice is grassroots, revival of grassroots democracy to re-engage a generation. And Randy made a very important point in that letter. You can go to today's Village Voice, online, newspapers, and you'll find that letter. And what he was saying is that we, over the past, I would say 30 years, we have raised, he said, well, 20 years, a generation of young people who do not know, understand local government and local representation and what it means to be involved in the development of their communities, what it means to be involved in the development of their what it means to elect their own representatives. I mean, yes, we've had two local government elections over the past maybe 30 years. We've had one, I think, in 2018, and then we've had another local government elections about 2 years ago. But local government, but what Randy was saying in the letter is the importance of local government, a functional local government system where people are participating in electing their representatives. They're participating in their the development of their communities. And so I'm hoping that at some point I'm going to be able to, we're going to talk more about this in terms of how our program, Building Our Dream Guyana movement, building our dream villages, building our dream communities, building our dream families, how this can fit into the how, right? Randy was explaining what needs to be done in his letter, but how this, our program, Development at Work, which is a part of the Building Our Dream Guyana movement, looks at the how. How can we do this? Very often I find that we wait on the government. You know, somebody was saying to me recently that we don't know what plans the government has for our community. So but I'm asking you, what plans do you have for your community? So this program, we're going to look at how we can help you to develop sustainable development and economic development plans for your villages, for your communities. So even if the local government system is functioning effectively, you must have a plan. You must have a plan as to how, let's say, 5-year plans. So we can assist communities to develop 5-year sustainable development. And I was, like I was saying on Tuesday, that the churches, for example, should have economic development plans for your members. And every church may not want an economic development plan, but some churches, because at the local government level, organizations which are a part of a local constituency or a local government community or a local community can be involved in or ought to be involved in the development of that community. And that also includes churches, it includes the mosques, it includes the temples. And so as I look around in Guyana, very often I think we complain that, you know, the government is not reaching our community in the way in which we would like them to reach our community. What this program is going to help you to do is to develop plans for your community that you can then share with the government, so that you can then share with the government, and so that the government can then contribute or facilitate your development plans for your communities, for your families. Families make up communities. So we're going to be talking about a lot about those things. But like I said, on this program, I'll be talking about land matters. And, you know, I saw this I saw this interesting report today from an organization, the Atlantic Council Freedom and Prosperity Council, Center. And this center is based in Washington, D.C. And it was interesting when I read what they do. The council, the center rather, they foster international development through database research on the relationship between freedom and prosperity. But they also focus heavily on the rule of law, the link between the rule of law and prosperity. And when I share with you, I'd like to share with you some examples on land matters that I've been a part of. And I think it hits to the core of African Guyanese and land. African Guyanese and property rights. And so they have, the council, they have brought out a report, and the report is on, the name of the report is Rule of Law and Economic Growth. I would really like to, I recommend this report to you, and I would really like to read this report, because a lot of what we're going to be dealing with in our legal discussions or discussions on rule of law as it relates to land matters, as it relates to different matters, we'll be looking at the relevance of the rule of law to economic growth. They also, I'm reading here an article on their website, and it says why the rule of law is the key to prosperity. So the rule of law is important, is the key to prosperity. Lessons from 30 years of data. The name of the organization again is the Atlantic Council Freedom and Prosperity Center. I just discovered them today. So the rule of law, we'll be talking about the land matters, like I said this evening. We'll be talking about legal matters, but we're also going to be talking about some financial and economic stability for families and how you can achieve that. On Thursdays, we look at environmental matters, building an environmental industry and community development matters. And on Thursdays, we're going to focus on land matters, law and legal matters, and financial sustainability matters. And there may be other things too. So let's look at Guyanese. Share the live if you've joined us. I'd really like you to share the live so that we can have more people being engaged in this discussion. At some point, I'm going to be having experts who are going to be on the program, right? I'm hoping that we can have lawyers, we can have development practitioners. When we talk about building financial stability into your family, and I'm hoping that we can have people from the insurance companies come in and talk about some of the services which they provide. Medical insurance that you can, I'm promoting that you build financial security into your family. And you can do that by having life insurance. If you're self-employed, you can get a life insurance, a pension plan with a savings. You can also get medical insurance. So, like I said on Tuesday, we have not really tapped into all that we can be and all that we can achieve. We've probably only tapped into about 25%. So how can we, so yes, while we depend on the government to do certain things, I guess a lot of us had great expectations from Guyana and our government after we discovered oil. But I think many of us were disappointed because the focus of the government seems to be more on infrastructural development as against on human development. For example, today I passed and I saw, the new There's a new Brigdam police station, a new Alberton police station being built. The Isla Penitence police station is new. The Timeri police station is new. Then we have new magistrates courts, new courts. But in terms of the human development is not being developed at the same rate that we're seeing the infrastructural development. We have new roads, but people still can't buy fruits every day. People still need jobs. People still need, people still go to the supermarket and buy 3 eggs, So how can we have, the sustainable development goals from the United Nations, Sustainable Development Goals? It focuses on leaving no one behind. But how can we have a development program in Guyana that leaves no one behind? And so on this program, Development at Work, I'm hoping that we can help you, help your families, or help you to help your families and your communities to develop in a way where no one is left behind. And so I'm going to start with land matters. And I'm going to be focusing heavily on African Guyanese and land, because when slavery was abolished in 1838, slavery in Guyana, slavery was abolished in 1838. From 1834 to 1838, we had the period of manumission, and that was the period where the slaves were learning to be free. And the slaves were here for hundreds of years before 1834, before they were freed. So after 1838, the British government in some communities around the 1840s, they started to give land titles, transports, etc., to these ex-slaves. So while I'm explaining to you why I'm particularly focusing on African Guyanese as it relates to land matters, East Indian Guyanese started to come to Guyana around 1838. I stand corrected. And the Portuguese and the Chinese started to come to Guyana just between the 1830s to, I think it was the 1850s. I'm going to pull up the information so that I can be correct before the end of the program. So African Guyanese, so when East Indian Guyanese had just started to come to Guyana, and I'm focusing on East Indian Guyanese because they're a larger part of our population. And then we have Portuguese, Chinese, we have 6 races. And Portuguese, Chinese, Europeans, etc. Amerindian, Amerindian. So we have our 6 races are Africans, East Indians, Chinese, Caucasians, or Europeans. Then we had the Amerindians, Chinese, and mixed races. And so by the 1840s, the British had started to give African Guyanese who were ex-slaves land titles. And so what has happened since they what has happened since the 18, what has happened since then? African Guyanese families, they have gotten these titles. This was since the 1840s. And in some cases, African Guyanese families have done nothing to update the ownership or those the title holders. So in 2025, African Guyanese have found themselves in a position where they have a lot of land, but the land is in the names of their foreparents from the 1840s all the way back to, I would say, the 1840s to let's say the 1940s. And I am speaking about based on records that I have researched so far. So many African Guyanese have focused on their right to the land and not necessarily ownership. So in many African Guyanese communities, what you would see the buildings, etc., on these lands, and many of them build their homes from, or their businesses with their own monies, because the land, in many cases, the land is owned collectively, or the land is family owned. They couldn't, no one person could use the land to borrow a loan from the bank, etc., to build a home and things like those. So what you find is that in 2025, many African Guyanese are still in that situation where the land is, the title holders are were their ancestors from the 1800s, the early 1900s. And so what do we do now? Because some of them are, or I should say some of us, in 2025, we are fourth generation. And so when you come down to, from the title holders in the 1840s, for example, the 1840s, 50s, 60s, 70s, 80s, 90s, and then you come down to 2025, where you have fourth generation, people are the fourth generation and the fifth generation, even sixth generation. So when you get down to fourth, fifth, sixth generation, in many cases, people don't even know who their ancestors were, who were the title holders. And so, and we're talking about large portions of lands. And so African Guyanese are challenged as it relates to regularizing these family lands. And I must say family lands, I'm speaking in the context of land which were owned by specific families, but the lands were owned by their ancestors, let's say in the 1800s, the early 1900s, by specific families. And then we have ancestral lands which were owned collectively, right? Like some of the villages on the East Coast, where you have villages which were purchased collectively by a group of ex-slaves. And so those villages are there, but because of by 2025, it's almost 200 years, over 180 years. And so the challenges from a legal standpoint how can African Guyanese sort these lands out, regularize these lands in a way that it would become an economic, or can create an economic pathway for African Guyanese out of poverty into prosperity. And so those are some of the things that we're going to talk about on this program, but also on other programs. So there are many villages on the East Coast, for example, East Coast of Demerara, for example, villages which were bought by African Guyanese and collectively by various families. And those lands are there. And so while we talk about prosperity, and while we talk about poverty reduction, while we focus on monies from the oil and gas industry, let us also focus on how can we organize the ancestral lands, the family lands, regularize those lands in a way that will benefit current and future generations economically. And so we it's a challenge. I can tell you that it's a challenge. And I've been doing a lot of work in land and land regularization, looking at succession planning, and as it relates to my own family over the past 30 years. I've been a part of a party to many cases in the courts. And the average village family member or the average villager does not understand the legal processes for regularizing these lands. And that's a challenge for villagers. And that's an area that I'm hoping that I can help, maybe with support from some lawyers, because I've been doing research. I've been a part of various court matters as it relates to these, not so much the ancestral lands, but family lands coming all the way from the 1840s. I mentioned in the last program, I'm also looking at pursuing studies in more research in a PhD program in law and law or jurisprudence. And my research will focus on land law and social policy, looking at how land can be a pathway from out of poverty into prosperity. Not only for African Guyanese, but I was reading an article in Barbados. I think they have some of these challenges also. So I'm hoping that my research can sort of lend some solutions, some recommendations to these kinds of ancestral family land issues around not only in the Guyana context, but in the Caribbean, because we have a similar history in terms of slavery and indentureship. So let's look at the family lands, for example. And I'll share some examples from my own family. And land can be one of the things that create a lot of conflicts in families, mistrust. And in some cases, some families prefer to leave the land there than to frontally address the land matters. And in some cases, families fight so much that they cannot agree on a process to resolve these land matters. So the land is there. In some cases, it's easier, and I'll share two cases which have been involved in the courts. It's easier for people to get a title for your ancestral land than for you to get that title. Because for you to get that title, other family members have to be involved. But for a stranger, they can get the title because the law says once they've been in occupation for over 12 years, then they can file for a prescriptive title. And in some cases, people do that. And so many families are left with the challenge of filed for prescriptive title for a portion of your land, and you have to go to court to represent that land, but the title holder died since in the 1800s. And in many cases, in law, we do not have people who, in law, they talk about the locus standi. The locus standi is that you must have, the law must recognize you as a legal authority or a legal representative for this land. And so in many cases with African Guyanese, we don't have that legal representation. Because even if our foreparents would have left wills, they would have left wills, let's say in the 1800s, they left executors or an executor. But from the 1800s to now, it's more than likely that executor would not be alive. And so since the executor for that will, there has not been any other process to have administrators, for example. Many African Guyanese families can be economically better off if they can organize their ancestral lands. Remember, we are looking at family lands, not family lands. This is lands which were passed on from one family throughout 4 or 5 or 6 generations. And then at another point, I'll have some people who are more familiar with the ancestral land aspect. I'm more familiar with the family land aspect because I've dealt with that extensively in my own family and assisting other families. So at some point, I'm going to have somebody come and talk about the ancestral lands and how we can organize those lands. So with family lands, so what do we do? I'd like to share some cases in the court, for example. And I'll also share some of what I've worked with, working with some families. I'm working with my own family. And it is very, very challenging to work with families to organize family lands. But if you can do that successfully, or even partially successfully, you can develop a pathway for hundreds of people in this family or in these families to come out of poverty. So I'll share with you some of what I'm working on with my own family. We don't have total agreement. The other thing that I'd like to say is that integrity is important. And it's important that people understand that you come to this with a high degree of integrity. And people may not understand it initially because, people always think that people have their own agenda. And that's fine because society has been so corrupt and distrusting. But once you continue to conduct yourself and your affairs with even family members in a way with integrity, then people come to understand that this person has the skills and the expertise, the know-how, and so they can really help us and work together. So in our family, so far what we've been able to do is we've been able to come up with a plan. We've put a team of experts together. So the team of experts, so in helping you, the team of experts that we've put together include surveyors. So we have surveyors because you have to survey the land. You know, you need to know where the boundaries for the land are located. And in some cases, we know where we think the boundary is. I've experienced a lot of cases, quite a few cases, where people think that the boundary is here, is at a particular point, but the boundary, when the surveyors go on the ground, the surveyors discover that that is not where the boundary is. And that is also another challenge. And so what we've done, we've put a team of surveyors together. We didn't set out to do this professionally. It just came together because you realize that, okay, we have a surveyor, but the surveyor is not enough. We need we need lawyers. And so we also have lawyers. And so we have lawyers. I'm telling you what you would need if you were going to set up a structure to regularize and organize your family land. You need surveyors who will survey the land and subdivide the land. I'll tell you about the subdivision in a minute. And then you need lawyers because the legal aspects of this land need to be addressed. In addition to the lawyer, you may also need researchers. Fortunately for my family, I have a master's degree in jurisprudence and rule of law. So I've been trained to do legal research. For example, I will share with you, you may have a will, and that will may state a portion of land, but it is not sufficient evidence to take to the court to say that this land is in the will. Because what we have found is that some of the wills from the 1800s, the lands were not described as lots. The lands were described as in rods. So for example, the will may have 10 rods by 600 rods, but it does not have the lot. And so a smart lawyer on the opposite side may say that, no, you need strict proof that your foreparents own this land. There's a term in law that is called strict proof. And so the smart lawyer on the other side may say that you need strict proof. Now, how do you find strict proof that the land was owned by your foreparents if in the will, the land is only described in rods? So the land is described, and in 2025, the land is described in lots. So the will says 10 rods by 600 rods, and the lawyer, let's say you have a matter before the court, and the lawyer is saying, a lawyer for the other side, but 10 rods by 600 rods for which lot? Remember, your will is from the 1800s. And in the 1800s, the lands were more commonly described as in rods. So in the 1800s, for example, you would say the 5 rods. I grew up hearing my foreparents, my father and my uncles and cousins and elders saying rods. So they may say the 10 rods, the 5 rods, the 20 rods. And so the lot number was not important. But when you come to a court and you have to produce strict proof that 5 rods in that will by 610 rods by 600 rods may not be sufficient evidence, right? particularly if you're not in, some people may say you're not in occupation. So so African Guyanese, a lot of what we take for granted, we may say we have a right to this land, but when you get to the court, you realize it's a totally different, as we would say in Guyanese Creole, kettle of fish, meaning it's a totally different matter. So these are areas that I'm hoping that I can help with based on my experience from my own family. So let's look at how do we address that. So if you have the land is described in the will as 5 rods by 10 rods by 600 rods, then the land may have, for example, a transport. It may have a transport. It may have, well, documents for tenure or land ownership are transports, certificates of title, grants, lease, and letters of decree, right? Those are the 5 I'm familiar with. I remember a police officer saying to me that the only documents in Guyana for ownership of land are certificates of title and transports. And I'm saying to the Guyana police force, no, right? Grants are a form of ownership, legal ownership of land. Lease are a form of legal ownership or tenure, you would say. Transports, certificates of title, and letters of decree. In the time when when we were British Guyana, letters of decree were issued by the governor. Remember, we had governors and we had, or the court of policy. The court of policy was just what it says, the court of policy, right? The court. And then they had the governors, or by the governors, the governor, there was a governor for one point, Demerara and Essequibo was one county. And then Demerara and Essequibo became 2 separate counties. So there was the governor for Demerara and Essequibo who could have issued a letter of decree as a form of land ownership to landowners. And then you can take that letter of decree, or you could have taken that letter of decree to the court and get a well, I guess since after transports were introduced, then that letter of decree could be taken to the court and a transport could be issued. But back in the 1800s, what you had, there were the letters of decree were a legal document of tenure, of ownership for landowners. And the letters of decree, the custodian of the letters of decree was the registrar of deeds. And there was a book of letters of decree. And letters of decree were recorded in that book. So for example, in the same way you have a transport, you have transport number 1 of 2026. And then you can go to the deeds registry and you can get a copy of that transport number 1 of 2026, because it is a part of the public records. The letters of decree, which were issued by the court of policy or the governors, were also a part of the public records, and they were recorded the transports are recorded in the property register at the deeds registry. Now it's the deeds and commercial registry, I think. And so in the same way, back in the 1800s, the letters of decree were recorded in the book of letters of decree. So there was a book that you could have gone and looked through, and you would have seen number X of 20 of 1872. And so those were the letters of decree. And so come to 20, so a lot of the land that African Guyanese own in 2025, remember we're looking at maybe fourth or fifth generation. For example, me and my family, I am the fourth generation. The generation after me is fifth generation. And their children are sixth generation. For me, as a fourth generation, I would have known my third and second generation. When I was a child growing up, the second generation would have been the elders. Some of them would have been in their 70s, 60s, 80s. And so I would have known briefly, because I would still have been young, the second generation. I would not have known the title holders if it's from the 1800s and the first generation. The second generation would have been the elders, and the third generation would have been like my parents, because my parents were third generation. I am fourth generation. And I'm going through this because very often when we talk about African Guyanese, we talk about them in the context of, I hear this thing that give a black person a box of cocoa rice and $5,000 and they're happy. But I am addressing some generational structure that was and still is a part of the African Guyanese ancestral history, economic history. And so when you go back, like I said to the so how do you, so now you have this will, and the will has 10 rods by 600 rods, but it doesn't have a lot number. Now that letter of decree, or there may be a letter of decree for that land that is described in the will, or there may be a transport somewhere. And I'm saying this to you because you may think that documents are not available. The challenge is where to find the documents. And because remember, you have to look at this for these documents in terms of years, in terms of some period. And that's why I said, so remember, you put in you're certain your family lands out. You're trying to regularize your family lands. And I'm sharing with you what system you need to put in place. So you have your surveyors, you have your lawyers. Depending on the size of the land, you may need more than one lawyer. Then you have your researcher. Like I said, I do a lot of the research for my family, and this is the legal research, and it helps our lawyers also. It helps the courts. And then you have your, depending on how you're going to develop this land also. In our case, we're developing two housing schemes, housing communities. So what we also need, we needed an engineer and we needed an architect. So we have our team of experts consist of surveyors, lawyers, an architect and an engineer and researcher. Then we have an ad hoc family management committee with a number of a few family members who have to also be neutral and fair. And so then there's a structure in place. So if you need support, I can help you, assist you to sort of put this system together. And so, like I said, it depends on what you want to do with the land. So in our case, we are developing housing communities. We now have a company that we'll be doing business with. We from the land, we hope to develop, for example, a microfinance scheme. And because you can't talk about all of this without the land must be able to bring the heirs of the land must be able to access some kind of financial benefit also. One of the things I hear from African Guyanese is that they say, we don't want family members to get titles for the land or to get transports in their name because they can buy fancy car and build fancy house. And I'm saying, some people also say, don't sell family land, right? I have been running up and down the court steps, and I've come face to face with somebody getting the transport for your land and getting millions of dollars from it because they have the transport. And because your family owned the land collectively, you are not, the land can't even pay the taxes. The land can't even pay the legal fees to go to court to represent it. And so African Guyanese is a level of pragmatism that we need to have. There's a level of being practical that we need to be, right? Or a level of pragmatism that we need to have in terms of if we're going to really address the issues as it relates to family lands and how we sort family lands out, and organizing them, regularizing them in a way that members of the family can benefit economically. It can be a pathway out of poverty into prosperity. I usually say to my family members, if you're going to be, if you're going to be a maid, you're going to be a security guard, whatever it is that you're going to be a plumber, you're going to be, let's organize the lands in a way that when you come home, you have a nice home. You have a nice home, and you're able to get that from your inheritance. So it doesn't matter what you're doing your job as a cash flow means of cash flow. So let's come back now so I've shared with you a system that you can put in place to organize and regularize your family lands. I'll be telling you, I share with you some more. We have gone to the stage where we're developing the 2 housing schemes. And so what we've done is that we've also developed building plans so that we can have some kind of structure in terms of how the buildings will be built. And we have the company, and the company is going to assist in facilitating things which have to be facilitated by an organization or by a company. So it's building a lot of structure into the family as it relates to organizing these family lands. Oh, how I wish that, you could have been sending me messages in the chat so that I could have responded to some of the questions that you may have. But feel free to contact me. My number is in the chat. My email is in the chat. So let me share with you 2 court cases, and from which I've been able to amass a lot of information in terms of, one, how the approach that many African Guyanese have to land. You can lose your land. So we've had a case where, I'll call names because these are court cases which are they're public information. They're a part of the public record. So in one case we have, I'm from Coverdon, and Coverdon, West Bank. So there's one case we had with a person named Karen Waldron. This is the lawyer Mark Waldron's sister. And that case has been going on in court for 30 years for a portion of land, of our family land. And finally, after 30 years, we were able to have come before a court and share our side of this land matter. By the time 30 years, the person had already gotten, Miss Waldron had already gotten transport for the land. And so I'm sharing with you very often what I find in villages. People say, oh, the people don't get transport, we can't do nothing about it. That is not so, right? And so remember, even if somebody got a transport for your land, that transport must have been gotten through a legal process. So when we went so they got a transport for the land, and this is where surveyors, I would like to say this to you, it's important in this at this level of this survey, because I'm going to point out some instances to you where the surveyors might not have been as specific in the description as they should have been, which can create problems. Because remember, to get a prescriptive title, you have to produce a plan. That plan has to be recorded in the Lands and Surveys Commission. And it is from that plan that the court will then issue the or grant the order for the prescription of title. So if the plan is wrong or it has incorrect information, then the transport will have incorrect information. So what has happened in this case with Karen Waldron? Let's say they applied for a transport for my family's land at B. They also applied for transport for A and B. But A and B has always been two separate portions of land with two separate transports. So they have created a complication by applying for the transport, which includes A and B. So then they have now created a new description for the land that never existed before, or did not exist. Yes, let's say that did not exist before. And so what has happened there is that, for example, 30 years ago, so the transport includes A and B. They were wrong to apply for B anyway, but they really meant to apply for B, but they applied for A and B. So one, it was fraudulent to apply for, because we for the transport, because what the law says, if you're there for 12 years undisturbed. So they were not there for 12 years undisturbed. But nevertheless, the point is they have so what they have done, they have a transport then. So the land now has three transports. It has a transport for B from the 1800s, a transport for A from the 2000s, and a transport that they have for A and B. So as far as we're concerned, our transports from the 1800s and from the early 2000s are the authentic transports. But they have a transport for A and B. And that's because, so part of it has to do with, I guess some people are just bold, right? And you have to challenge them. So that matter is before the court. So the court now has to tell us that their transport for A and B is more superior or authentic that our transports for A separately and for B separately, as far as we're concerned, their transport is fraudulent and our transports are authentic. Because you can't just come and get transport for my land, right? Or you can't just go and get transport for somebody else's land and the neighbor land too. So what they did, they got transport for somebody's land and the neighbor's land too. In our family, we are neighbors also. So it's still our land. So I'm sharing that with you now. So what the average person might say, the people don't get transport, you can't challenge them. But I'm saying, yes, you can challenge them. So we're now in the court. So we've been to the high court for fraud. But what the judge, Justice Harnan, has said in the high court is that he did not find fraud, right? We did not prove a case of fraud in the high court. But him saying that we did not prove a case of fraud, he didn't say that the land is not ours, because he couldn't say that because we have transports for the land. So we've now taken that case to the Court of Appeal. And the Court of Appeal now has to determine that we can throw away our transport for A in the bin, throw away transport for B in the bin, and their transport is the valid transport, right? And this is not a case, this is a case where, so that case is before the court, and I am the legal representative for my family before the court in these matters. And so the next, I'm not the lawyer representing, I'm the representative. And so, or so to put it this way, I have the locus standi, right? For those of you who understand the law. Locus standi meaning that you're the person who can go before the court and represent this land. And then there's another matter. This one is interesting. I'm actually writing a book on this one. So this one is where there was a letter of decree for the land. But the executors for the estate, they've never updated the letter of decree to a transport. So if you go to the deeds registry and you go through the property register, you will not find a transport in the name that we think it should be in. So what happens there? So this is a case where somebody else, right, has a transport for let's say D, and they're claiming that the registrar of deeds, I'm just trying to tell you how people are sharing these cases with you, how people are clever in terms of land matters. So this person, I'll call his name Edward Wilson. So Edward Wilson got a transport in 2022 for a land, let's say the land is at D. But Edward Wilson sees another portion of my family's land at C, and that land was not, he felt that the land was vacant. So he will go to the court to get ask the court to change the description of that transport from D to C, which is this land that appeared to be vacant. This case is so interesting that I'm writing a book, like I said. And so he went to the court with the transport for D and said, no, the deeds registry made a mistake in 2022 when they issued him the transport. And the description in the transport should have been C instead of D. So he got this transport in 2022, went to the court in 2023 to say that in 2022, the registrar of deeds made a mistake in the description of this property. Justice Harnanan, again, was the judge in this matter. So the registrar of deeds was a named party to this matter. So the registrar of deeds in her defense said, no, the deeds registry did not make a mistake. The transport is for D, not C. The lands and surveys was also a named defendant in that matter. The lands and surveyors said to the court, no, what our records show is that this transport, the description in this transport is not for C, but for D. And then we went to the court to tell the court that both C and D are my family land, and these lands are in the will. But the challenge with one of the lands in the will is that there was a letter of decree for one of the lands. One had transport and one had a letter of decree. So remember, when they checked the property register, you wouldn't see a transport because there was not a transport. So Justice Harnanan dismissed that matter. And what was interesting, the lawyers I'll come to the lawyer in a minute, right? And so they so Edward Wilson then had sold the land apparently to one Wayne Heber. And I'm calling these names because they were part of the court files, and the court files are public records, right? And these matters were concluded. So Edward Wilson then sold the land to Wayne Heber, and Wayne Heber came before the court, and he was claiming the land in that matter. So Wayne Heber appealed the matter, and he said the judge was misled, and the land is indeed Edward Wilson's land, and the land is his land. And once again, we appeared in the court, and we informed the judge. Well, there were two judges at that time. The judges were Justice Joy Prasad and Justice Nicole Pierre. And we informed the court that, the land is our land. And these lands are in our will, which is a legal document. And the judge at that appeal level, the matter was refused. The appeal was refused. What was interesting in this case is that the defendants were the lands and surveys, the deeds registry, and then there were my some neighbors who were, let's say they're at so the land is C and D, and the neighbors are, let's say, at E. So C, D, E, right? And they and so the land had and I'm telling you how these matters can be complicated. And if you don't have people or lawyers who really know what they're about, you can lose your land. And so fortunately, like I said, I've spent 30 years doing this kind of research. And so I could have helped, assisted the lawyer with the legal research, etc. I'm also, like I said, going to do my PhD in land law, the research for my PhD in law, in land law and social policy. So, which will, allow me to do some more in-depth research. So when so that was the appeal. And then in the defendants now was the neighbors, as well as and then there was another man named Deolal Puran. Deolal Puran had bought a portion of my family's land again from the neighbor. I'm just sharing with you how so you may look at this and say, oh, this is complicated. Deolal Puran got a transport, there's nothing that we can do. Even the police said that. The police said the man got a transport, and all y'all have is a long list of properties. I said the long list of properties is called a will, and it's a legal document, right? As a matter of fact, the police was more than disrespectful. The police said the man got Deolal Puran got a will, got a transport, and all y'all have is a historical document with a long list of properties. Now that historical document is called a will. He's very disrespectful, but that's besides the point. So it's very disrespectful, but it's also trivializing the legality of our claim and our history to land. Not only us as my family, but for Black people. Let's come back to the point nevertheless. So they appealed so after so Justice Harnanan dismissed the matter because the Registrar of Deeds said no. The Registrar of Deeds didn't make a mistake. The description in the transport is the description in the transport. The appeal judge is not a appeal court. The appeal judges dismissed the matter, refused the appeal, because the appeal judge said the description in the transport was what was intended to be the description in the transport. And then this man, Deolal Puran, was a defendant in the matter with Wayne Heber, and Wayne Heber that said he bought the land from Edward Wilson. And he did not file a defense in that matter. He did not file a response as a respondent in the appeal matter either. But he showed up with a transport to say that he has a transport for the land after Justice Harnanan and dismissed that matter. So what it means is that they were using two transports to try to get the land, right? They were using the transport from Edward Wilson, and they were using the transport from Deolal Puran to get the land. Now, if you don't have people who can really do research and good lawyers, you can lose your land because it gets complicated, right? It gets complicated even for the judge or the judges. So Deolal Puran now claimed that he has a transport for the land. And Deolal Puran went and he leased the land now to a UK or Bangladeshi company. So what he's done now, he has passed on that issue now with us, complicated our lives more. And he's now leased the land to a Bangladeshi and or a UK company, I think it is. So here you are now watching all these people coming on your land, trying to build on it and all of that. But nevertheless, we ended up in court. The matter is currently before the court. But one of the things I'm coming back to again is strict proof. So one of the things that this matter, I'm not going to talk too much about it before the judge banned me from talking about it because I'm a party to the matter. I'm the defendant and Deolal Puran is the plaintiff. So before the judge put a ban on me for talking about the matter, I'm going to sort of condense it here. So they are concluded rather here. So that matter now is before the courts. Even though it is in our will, we still had to find some other document that in terms of what the law may say strict proof. Fortunately, now this will was since the 1800s. How do we find in 2026 strict proof? Fortunately, I was able to do some research. And when I said research, some real digging, and we found strict proof. So that strict proof is now before the court in the matter, that the land that is in the will is indeed that portion of land. So this is another evidence, supporting evidence. As a matter of fact, that now becomes the lead evidence that the land is the land that was in the will. But I'm sharing with you, I'm going somewhere with this. I'm going to wrap up in a minute. I'm sharing with you how much we take for granted. We say it's our land. I have a right for the land. So while we sit down fighting among our family members, somebody is before the court trying to get transport for the land, and you don't have title because your title holders died ages ago. And the strict proof, and you don't even know because you, like me, you're fourth generation, fifth generation. So let's go to, so what we have done, we got that strict proof and we wrote the Registrar of Deeds and provide that strict proof. We wrote the lands and surveys to provide that strict proof. We wrote the, but we even wrote out the police, the commissioner of police, because this matter, this matter here, they were determined to get this land. So we're now on the 738 matter and police matter with regards to this land. And we are determined to fight for this land. So we're on the 8th matter. So, but there's so much learning, there's so much knowledge that I have gained, that we legally, I have learned so much. I think my lawyers have learned so much, or the lawyers in this matter. And my family, we've learned so much. And so the lands and surveys also must find this case interesting. So what has happened in that case? So my neighbors were who sold the Olalpura and the land as is claiming, but the land is not a part of their transport. So what we needed was to find that strict proof, and we were able to find that strict proof, and it's with all of the relevant authorities and the courts, including the police and the commission and the crime chief. That's in the event that it goes in that direction. And so the other thing is, in 1962, and this is another thing, this is surveyors, I'd like you to listen to me carefully. So in 1962, when my neighbors were doing their surveying, the surveyor put that the land that he was surveying is not owned by anybody. So because he put on that plan that the land he was surveying was not owned by anybody, a man said our land belonged to somebody else's land. So the surveyor then wrote our land as that other person's land. But when we found the strict proof and the evidence, the person who this land, our land is recorded in the plan as the owner of our land, is not the owner, because we were able to find the documents which says that the same land that the surveyor were surveying for my neighbors, and he said that the land was not owned by anybody. The person's land is now a part of my neighbor's transport. So our land then was, all of these years from 1962, was seen as this person's land, because the surveyor put in his plan that our land is that person's land. And the land he was surveying was not owned by anybody. But if the surveyor had put the owners of the land that he was surveying in 1962, our land would not have had the issues it's having now, where it was felt that it was somebody else's land. So all of that information we were then able to provide to the Lands and Surveys. We sent it to the Commissioner of Lands and Surveys. We sent it to the legal officer at the Lands of Surveys. And we sent it to the Registrar of Deeds and asked her to correct the records. Because the land that was claimed all of these years as this other person's land, because of the mistake that was made in this plan, here is the strict proof that it is my family's land, and it is not, and it is a part of my neighbor's, the other person's land is a part of my neighbor's transport now and land. And I'm sharing with you the complexity. So that matter is now before the High Court. But Diolal Puran, who bought this land from our land from my neighbor, could not have properly gotten transport for the land, because my neighbor did not have the legal authority to sell our land. Where this is also explosive to is that if the claim that, well, maybe don't let me go into this, because like I said, the matter is before the court. The last thing I'd like to say about this is that the lawyers for Diolal Puran and Edward Wilson and Wayne Heber are from the Attorney General and in Landlal private legal law firm. So the lawyers who are representing Wayne Heber with another transport, with the other transport, are from the Attorney General's private law firm. And the lawyers, the same Attorney General private law firm is represented Deolal Puran with another transport for the same land. Now, I'm not making conclusions here. I will provide you with the information. I am just trying to tell you what we are up against as it relates to our lands and the extent to which people will go, even legally. So the court system has become a tool for some people. And so but we didn't mind. We knew that the land was ours. We had the evidence. And so we didn't mind whether it was the Attorney General's private law firm. We were prepared to fight it. And we are still prepared to fight it. And we won 2 cases against the Attorney General's private law firm. And we are in court with this other case with Deolal Puran. And so the other thing that I'd like to say is that and I'm wrapping up here, is that so what has happened now is Deolal Puran has leased the land to this Bangladeshi company and Bangladeshi UK company. And there's a level of bombasticness, if I can say this, that we saw from Deolal Puran, for example. He was bombastic. He came and he broke down my elderly relative's fence, and he built his own fence, built up the land with sand, and he was just moving through because he knew that, you know what, I am well connected, and and there's no way they can get me to move off of this land. And I remember my relative saying that the truth shall set us free. And I think if there's a lesson that the Attorney General's law firm and the lawyers from the Attorney General law firms, Deolal Puran, my neighbors, Heber and Wilson, are learning from this, is that you can't fight truth. The truth is incontrovertible. The truth doesn't go anywhere. At the end of the day, you build up the land, you put a fence, you do whatever you want to do. The truth is right there. What was also interesting in this matter is even the police used to come and prevent us from going on the land because they were so well connected that whenever we went on the land, the police used to come and tell us that we had to show the transport because Puran got a transport. And we kept fighting. And here we are now, we're before the court, and I can't see the court saying that the transport that Deolal Puran has, that for the land that he bought from our neighbors, who did not have the legal authority to sell the land, that his transport is proper. I don't see the court doing that. So I would say that, so I would end it here because, like I said, I don't want the judge to ban me from talking about this case. So what I'm saying to African Guyanese, this case here, during the period of during the period of the injunction, this is another thing. When there is an injunction, if you got Deolal Puran had he had some power behind him. Like I said, his lawyers were from the Attorney General's law firm, private law firm, and so he got an injunction to stop us from going on the land because he had a transport. All right, but while the case was being tried, but then he was building while the injunction was in force, and all we could have been doing is just watch him there building. You see, but there are things that you can do. What we did in that case, we wrote the chief executive for the Central Housing and Planning, because for him to have built a commercial structure, he had to have gotten a plan and his plan approved by the Central Housing and Planning Authority, which is a part of the Ministry of Housing. So we wrote the chief executive and copied the legal officer at the Central Housing and Planning. And we requested an immediate cease and desist, that they issue an immediate cease and desist order until this matter is finished in court, because he's building on our land. I'm sharing all of that with you to tell you that while you're in your homes sleeping, or while you are, us African Guyanese, we're fighting among ourselves, family members are fighting one another, people are before the courts, and these are some of the processes that you have to go through. And so this brings me back to, in 2026, you have family lands. The title holders were since the 1800s. Somebody comes with a transport. Now you find yourself before the court having to defend this land without a transport. And I can tell you from experience, the process was difficult. And they know that it's difficult. That's why they carry you through that process. So African Guyanese, let us organize, regularize our lands. In many cases, the lands are enough to be subdivided among family members. And this thing about if people get title and transport, they can build fancy houses and build fancy houses and fancy and buy fancy car. D.L. Puran was renting the land for millions of dollars a month, our land, while we were watching him do that, because he had a transport, or he thought he had a transport for the land. So I am saying that in some cases, what is going on in our heads, it's putting us at a disadvantage. So I shared with you some of the things I'm working with my family and other families. And I try to come to this with a high level of integrity. And so that I can build trust. And so you have to build trust. So if you would like to sort out your family lands, call me, contact me, and I would be more than happy to support, to give you some kind of support. And I need to just tell you, so our lawyers are Mr. Sanjeev Dattadin and Miss Anganu. So those are our lawyers, and Mr. Puran's lawyers are the lawyers from the Attorney General's law firm, which is, and so we have so far won 2 cases in relation to this land. And we have this other case before the High Court with D.L. Puran. And let's see how the court will rule in that matter. I would like to say too that the other thing I'd like to say before I close is what was also, I thought, bombastic and interesting was the Registrar of Deeds was a named party to the 2 matters with Wayne Heber and Edward Wilson. And the Attorney General's law firm was the lawyers for Wayne Heber and Edward Wilson. What I would like to compliment the Registrar of Deeds for, the Attorney General is the Registrar of Deeds boss. The Attorney General is in charge of the deeds registry, but the Registrar of Deeds in her defense stuck to the truth. And the Registrar of Deeds said in her defense that what Wayne Heber was claiming, that the land that in the description of the transport in C is really for B, the Registrar of Deeds said no. She did not think that, oh, the Attorney General is my boss, and so if I bring the truth, put the truth in my defense, then I may come into some kind of conflict with my boss, who's the Attorney General, because it is his private law firm that is representing the plaintiffs. No, the Registrar of Deeds stated the truth, and I commend her for that, because justice must work for everybody. Because, and then the other thing is the lands and surveys. I'd like to compliment the lands and surveys, because the lands and surveys also stuck to the truth. They lands and surveys, they kept to what was truth, the truth and factual. And so Justice Harnanan dismissed the case, and then the appeal judges refused the appeal. So we won those two cases. And so, but here is where I will end on this note. As a citizen, I remember writing the Chief Justice in this matter with Deolal Puran. And I ended my letter to the Chief Justice by saying, Honorable Chief Justice, acting Honorable Chief Justice, is this the most dignified process for justice for the ordinary Guyanese? I said, because what is disturbing is that the Attorney General's private law firm is at the center of all of these matters, where they're using two transports to get this land. They didn't get one, and they're using the court system to legitimize one of these transports for this land. And against the people who are saying that this land is our land. What was interesting also is that even though Deolal Puran did not file a defense in the matter with Heber and Wilson, when they were claiming the same land that he said he has transport for, he's now coming to say that he has a transport for the land. So if the judge, Justice Harnanan, had granted the transport to Wayne Heber and Edward Wilson, what would Deolal Puran had done? He did not file a defense. What was even more interesting in this matter is that my neighbor who sold Deolal Puran the land was also a named party in the matter when Wayne Heber and Edward Wilson were claiming the land. And my neighbor did not file a defense, or neighbors, to say to the court that the land that Edward Wilson and Wayne Heber were claiming as theirs, she had sold it to Deolal Puran, and he has a transport for it. But Deolal Puran shows up now with a transport after that matter to say that the land is his. So even though we went before the court and provided the evidence that the land was ours in the first instance and in the second instance, so what he's saying is throw those court matters away. I don't care what y'all went and tell the court. I didn't have to file a defense. The land is, I am going to claim the land. You understand? And to hell with y'all. What this says is that he must have thought that he has some kind of power that he could have, irrespective of not filing a defense, and are we representing our land in court? Throw that away. I am coming with the transport, and I'm going to break down your fence, build up the land with sand, put up a fence, and y'all do what y'all want to do. And the Attorney General's private law firm was representing both persons with two different transports. I'm not going to tell you that this is corruption. You determine if it's corruption. But what I'm saying, that is what is happening in our country. And so African Guyanese, the decision that you have to make as it relates to your lands is to update the title holders. Update the lands and put the lands in the names of the title of the current people who are alive. And this thing that people are saying that you want to have the land so complicated that you don't want people to get individual titles. I'm saying that it's a way of keeping heirs of the estate of the land in poverty. And what I'm also suggesting is that you, if let's say, I'll talk about this at another point because I have to end at some point. I'm going to end here, right? But these are things that we're going to be discussing because I watch people and listen to people at the village level. We say all sorts of things, but you see, when you get to that court, you can't go to that court and tell the court you have a right, you know. You can't go before the judge and tell the judge that you know that this land is your own. The other party, even though they know that the land is their or not their own, they're asking you for strict proof. So when you're thinking that you have a will, they're asking for strict proof. Now you have to go back to the 1800s and dig up to find that strict proof. And this is at the level of the Attorney General's private law firm. So who do we go to? Where is the neutrality? Right? Like I said to you, the Attorney General Chambers was representing the registrar who had a different view against his law firm. Because the registrar probably said, I want nothing to do with this. But they're saying it is not so. And so, as an ordinary citizen, who do we go to? We couldn't go to the Attorney General because the Attorney General in this case is compromised because it's his private law firm. And I can say that because I wrote him and I asked him to instruct the private law firm to withdraw this matter. So I know, and I copied that letter to the Chancellor and the Chief Justice. So I can say, and I copied it also even to the President and the Vice President, asking him to ask his private law firm to withdraw this matter based on all these things that I've mentioned to you. So I can say that, in my view, the Attorney General is compromised in this case. And so as an average citizen, where do we go if the Attorney General is compromised? Hence, my suggestion. I think the government needs to separate the office of Attorney General from Minister of Legal Affairs. So I think this current Attorney General, Anil Nandlal, I think that he represents the government well. So he can be, well, you know, quotation, but well, I mean, he's passionate about representing the government from a political standpoint. Let's say from a political standpoint, but may not necessarily be the same with policy, legal policy, etc. But I'm not here to evaluate the Attorney General. I don't have the authority to do that. But what I'm saying is that I think that what we need is to separate the office. So the Attorney General, this current office holder, can be the Minister of Legal Affairs. But the Attorney General should be somebody who is neutral. For example, in a case like this, Deolal's Puran interests will be represented. Wayne Heber and Edward Wilson's interests will be represented. And my family or your family's interests will also be represented. I'd just like to say at the beginning of the program, I wanted to clarify the years when we've had the years when we've had the African Guyanese came to Guyana, and right. So the first, and when Portuguese, Chinese, because I might have given some not the quite accurate information in the beginning, so I'd like to clarify that. So the first batch of Portuguese came to British Guyana in 1834 to 1835. The first batch of Chinese came to British Guyana in 1853. The first batch of East Indians came to Guyana in 1838. So African Guyanese, remember I say that African Guyanese would have been then in Guyana we would have had, in terms of land ownership, we would have had, and then the indentureship ended. The East Indians and the Chinese and the Portuguese, they came as indentured servants. And indentureship ended in 1819. This is the East Indian indentureship. 1819, I think it was, or 1819 or 1818. And then, sorry, not 18, sorry, 1917. I have it right here. In 1917, Indian indentureship ended. So the African Guyanese would have been occupying or owning land for, in 1917, East Indian Guyanese were still indentured servants. And remember I said African Guyanese were getting titles for land since the 1840s, which was 2 years after slavery was abolished. So when we look at land ownership in the Guyana context, we cannot look at African Guyanese land ownership and East Indian Guyanese land ownership and Portuguese and Chinese Guyanese land ownership in the same legal context. We'll talk more about this. But while we are fighting these battles, we also need to get our house in order. And our house is not in order. And so we'll talk more about getting our house in order when we meet again. It was wonderful being with you on this program. Share the program with others. And I'll be back again. The program is aired live on Tuesdays and Thursdays from 7 to 8. We start late sometimes. We started late again because we had some technical difficulties, but I hope that we can get to a point where we start at 7 on the dot and we end at 8 on the dot, because the program is supposed to be an hour. But nevertheless, you can go to my YouTube channel, Audreyanna Thomas, and you'll be able to find the program. Share it to Facebook pages, your Facebook page, share it with your colleagues, and let people get this kind of knowledge and information. And if you'd like to contact me, you're free to contact me. Have a wonderful evening. God bless you. And we look forward to building our dream Guyana, building our dream village, building our dream communities, building our dream families, and building our dream lives. Goodbye.